crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, has responded on the speculations suggesting that a resignation from Gensler is probable. After the historic verdict of the U.S. session on July 13, the U.S. Securities and Exchange Commission, SEC, has replied to the ruling by Judge Torres, the long-awaited summary ruling in Ripple v. SEC had just been issued. The presiding judge, Annalisa Torres, came to the conclusion that XRP did not qualify as a security under specific conditions. The SEC's reaction to Ripple's shared victory. The U.S. SEC went home with a victory, albeit a partial one. Following criticism and mockery from the XRP community, the Commission has made clear its position in light of the court's ruling. The SEC may be examining the matter further in light of the comments published by Fox Business. Paraphrasing some of the reply, nonetheless, the agency concedes that it won since the judge ruled that Ripple offered and sold the tokens as investment contracts in violation of the securities laws in certain circumstances. The court ruled that Ripple's sale of XRP to financial institutions was a violation of securities regulations. They were given permission by Judge Torres to sell the asset to the public. Notably, the court agreed with the Commission that the Howey test applies to the securities investigation of Bitcoin transactions. As shown by the summary ruling, the court also disagreed with Ripple's definition of an investment contract. However, the court's judgment made it obvious that the SEC does not have limitless authority over crypto, which may account for the fervor in the crypto market. In response to Ripple attorney John Deaton's request that exchanges list or relist XRP to indicate support for the verdict, the Kraken and Coinbase markets have already done so. This shows the industry's alignment, with crypto leaders like Binance's CEO congratulating the Ripple camp on the victory. The case that the Commission had against Coinbase, which had sold 13 tokens classified as securities via the exchange rather than on launchpads like ECOS and IOs, is rendered completely moot. CoinDesk contributor Preston Bren, meanwhile, believes that the judgment from July 13 merely guarantees continuing uncertainty for crypto issuers, and that only Congress can rectify the situation. However, now that they have been vindicated that Gensler no longer has exclusive jurisdiction over them, altcoins have flashed green following the news of the ruling, suggesting a buying frenzy that saw XRP naysayers miss out on 70z gains while holders of Solana, Sol, Polygon, Matic, and Cardano, ADA, raked in around 20 profit. In its statement, the SEC discussed Ripple's partial victory and how the court had rejected the defendant's proposed test. The judgment will be reviewed by the agency, which might lead to a trial down. Since late 2020, the SEC has started litigating against Ripple. As we enter the third quarter of 2023, anticipation for the court's decision on this protracted dispute only intensifies. The majority of people expect a favorable verdict for XRP before the end of the third quarter this year. The question on everyone's mind is, when will the Ripple and XRP lawsuit end? Members of the internet crypto community had a brief conversation about this on Twitter. Let's analyze the many factors that have contributed to the XRP lawsuit's protracted duration. This tweet suggests that both parties have been stalling in order to gain an advantage in the legal battle. The case received a lot of attention, according to one responder, but if it drags on too long, people will lose interest. According to this remark, XRP's value will skyrocket because of its practical applications. So, in their view, XRP investors will see their wealth grow exponentially over time. As a result, the SEC is trying to lengthen the litigation in the hopes of reducing the number of persons who benefit from it. Another comment suggests that the judge in the XRP litigation is waiting for the parties to settle rather than going to trial. At the same time, Ripple is allegedly postponing the litigation in order to bring on additional AUD, according to the same answer. In the latter scenario, Ripple is able to amass consumers, clients, and users who are willing to purchase XRP at a discount. Mike concludes my remarks in my answer. They also note that they anticipate the XRP case will conclude in the next month or two, bringing us closer to the conclusion of QA 2023. Furthermore, another statement claims the XRP case will not be resolved for another year. However, they don't provide any justification for why they hold this opinion. Instead, another comment suggests why the XRP case may be over in a year. The American judicial system is notoriously sluggish, so it is probable that any holdups are due to that. The XRP and crypto community as a whole is behind Ripple in this protracted legal struggle. The SEC is said to have a paltry 3% chance of victory at best. The recent drop in XRP pricing is consistent with the first explanation. The longer the judgment takes to come down, the more investors lose patience and sell at a discount. Meanwhile, believers are stockpiling XRP, hoping for their time to shine. On July 11th, John Deaton shared details on Judge Annalisa Torres' extraordinarily high rate of compensation for her rulings. Since December, when reply papers were submitted by Ripple and the USCs, the XRP community has been waiting for Judge Torres' ruling. 7 months have passed, but Ripple isn't Judge Torres' only case. He said that Judge Torres has failed to issue a ruling in the Thor Equities case despite the fact that the reply papers were submitted in December. However, he disclosed that Judge Torres waited 6 months to declare her judgment in the Fitzgerald case and numerous other cases, and 7 months to announce her decision in the Quiller, Ince vs. U.S. case. Since Deaton has put in the same amount of time as her opponent, she thinks she has a good chance of winning this month. David Schwartz, ECTA of Ripple, responded to Deaton that he anticipates a summary judgment verdict by the end of September. Since Judge Torres' ruling has never been delayed for more than 9 months, Deaton says he agrees with Ripple Q David Schwartz. Although Deaton did not look at every instance, he didn't find any that were longer than 9 months, although one was slightly longer than 8 months. John Deaton, an outspoken advocate for Ripple, has predicted that in her future summary ruling, Judge Torres would provide a detailed answer to the topic of whether XRP is a security. Beachy was once sold as an investment contract, Sexy V, shavers, but that particular sale didn't transform BTC into anything other than what it is, a digital commodity, he said. Deaton further said that Judge Torres will address the problem of secondary sales using XRP, which is something many seasoned attorneys would rather avoid. The underlying asset and secondary market transactions are issues that I think Judge Torres has to consider. Was she able to rule without becoming bogged down in the details? She could, of course. However, not addressing these issues would be an even greater act of judicial activism than considering the sexist theory, he said. Deaton used a case concerning the Telegram messaging service from the year 2020 that was heard by Judge Castile to buttress his claim. The SEC's decision to intervene and prevent Telegram's planned distribution of Gram tokens marked the beginning of this legal conflict. After a failed issue ICO for the Telegram Open Network, Judge Castile sided with the cease and ordered Telegram to pay back investors $1.02 billion. Remember that the SEC's position was that Ripple's behavior resembled that of an iShow on an ongoing basis, with each sale of XRP being seen as part of a larger scheme involving securities. Deaton, meanwhile, made it clear that the XRP issue was different from the Telegram case since the latter comprised an initial coin offering, IQ, with written contracts. Deaton said that the XRP ledger, XRP, technology, which underpins XRP, has been in use and freely traded for over 7 years. Unlike the Gram coin, which was restricted to anyone outside of the SEC, XRP was allowed to be owned by anybody until 2019. The dispute between the SEC and Ripple centers on the question of how XRP may be traded on the secondary market. The SEC charged Ripple with providing an unregistered securities, but it did not differentiate between Ripple's direct sales and the secondary market trading of XRP, which led to some misunderstanding. Deaton has speculated that Judge Torres may explore this issue because of an earlier examination in the SEC CVs, El Bri action. Judge Torres' summary judgment ruling might provide clarity on XRP's security classification, which could have far-reaching implications for the cryptocurrency sector.